Senator Cruz, it's your turn now.
Thank you, Mr. Chairman. Judge Gorsuch, congratulations on making it through more than half of a long day and making it through with flying colors. I think this hearing has been helpful for illustrating the proper temperament and approach that we should expect of a federal judge, and I think you are acquitting yourself in an excellent manner. This hearing is focused on a lot of weighty matters, so let me start with something lighter and a topic on which I believe you have some familiarity. What is the answer to the ultimate question of life, the universe, and everything?
42.
Thank you, Judge. And for those who are watching who may be a bit confused at this exchange, could you explain what it is to which we're referencing?
Well, Senator, sometimes we have young people who come to court to be sworn in. Often they're my law clerks. There are a couple of them right there. They haven't enjoyed this privilege yet. And they come to court and they're very nervous. And the clerk tells us about their career and their record, and then submits them to the court. I move their admission to the bar. Are there any questions from the bench? And it's sort of like this. It's a bit intimidating. This has been a reminder to me of what it's like to be down here rather than up there. And the last time I had this kind of interaction with Senator Lee, it was when he was down here and I was up there. At any rate, I sometimes ask them that question to put them at ease. And they all know the answer, and they all know the answer because they've all read Douglas Adams' Hitchhiker's Guide to the Galaxy. And if you haven't read it, you should. It may be one of my daughter's favorite books, and so that's a family joke.
Well, it is a book I very much enjoyed as well, and it is, I think, a delightful example of the humanity of a judge that your record has demonstrated. You began your career with the opportunity to serve as a law clerk to Byron White. Byron White is an extraordinary man. Byron White was the only justice that John F. Kennedy put on the Supreme Court. Byron White is, I believe, in fact, I'm quite certain, the only Supreme Court justice in history to lead the NFL in rushing, and also to graduate first in his class from Yale Law School. Could you share with this committee what it was like to be a law clerk for Byron White and to interact with him every day during your clerkship?
You know, as I said, he really was my childhood hero. And to actually get picked out of the pile, to spend a year with him, as Senator Lee's dad did, that's something we share in common too, was and remains the privilege of a lifetime. And it has everything to do with why I'm here. I wouldn't have become a judge but for watching his example. And the humility with which he approached the job. And I don't mean a phony humility. I mean real humility. Every day. He always said 2 heads were better than 1. He'd sit down in my office, plunk himself down in a chair across the desk. We'd be talking about a case and say, Always started with a grunt. I mean, that's how he started a conversation. It was like, hello. So what does the great Justice Gorsuch think about this one? And you were expected to have a view about pretty much anything and everything that he asked. And he'd just sit there and chuckle at you. And he'd laugh at you. And you're wondering what he thought. He never revealed his hand. And he'd just walk out of the office saying, oh, that's what Justice Gorsuch thinks. Okay. And then he'd go back and he'd think about it himself. And then he'd come back in again. And the whole thing would repeat itself. As he was working through each case himself, he'd want to bounce ideas off of this know-nothing 20-something-year-old kid. And that, to me, taught me everything about what it means to be a judge. And the fact that when asked his judicial philosophy in this sort of setting, he said it's to decide cases. And I know a lot of people think that's just mundane or maybe cover dishonesty in some way. It's just not true. It was the humility of the man. That he knew that lawyers worked really hard, because he had been a lawyer, a workaday lawyer for 14 years, I think it was, in a law firm. He tried cases, small cases, big cases. And he knew what it was like to have to be the lawyer in the well, and how hard it is to have all the answers, how easy it is to ask the questions.
Now, you and I both had the experience of clerking at the Supreme Court after Justice White had ended his time on the basketball court.
Yeah.
Or maybe you were luckier than I. For those who do not know, above the Supreme Court, above the roof of the courtroom, is a basketball court, which is referred to tongue-in-cheek as the highest court in the land. And Justice White, for many years, would play in the basketball games. NFL Hall of Fame football player with a bunch of pencil-neck law clerks.
Yep.
And his elbows and fouls were legendary. When I was clerking, he was no longer playing. Perhaps, were you lucky enough to get him up on the basketball court?
He would come up for a game of horse with the clerks, former law clerks at reunions.
How's his jump shot?
His best shot at that age, we're talking in his 70s, late 70s, was from the free throw line back up over his head, like that. And he could hit it pretty regularly. His eye-hand coordination was just uncanny. So I remember those law clerk reunions at the basketball court where he'd come up and stiffly throw it up and sink it. And I remember walking through them in the basement, arm in arm. Like to walk arm in arm at that age. And we'd walk past all the portraits of all the former Supreme Court justices, which are down in the ground level. And he'd ask me, Ron, how many of these guys you honestly recognize? And I was one of those pencil-neck law clerks. And the truth was, I thought I knew a lot about the Supreme Court and the law. And the answer was about half, the honest answer. And he said, me too. And he said, the truth is, we'll all be forgotten soon enough, me included. And I remember saying, Justice, that's impossible. You're one of the greats. No way you're going to be forgotten. His portrait now hangs down in the basement.
Well, there is wisdom in that humility. Let's shift to another topic, a topic that has been raised some in this hearing, which is there are some Democratic senators on this committee who have raised a challenge to the notion of originalism, and indeed have painted originalism as some quaint and outdated mode of interpreting the Constitution, have suggested that their view of the Constitution, it is a living, breathing, changing document, flexible enough to accommodate whatever policy outcome the particular judge might desire. The alternative is that a judge is obliged to follow the Constitution, the text of the Constitution, as informed by the original understanding at the time it was adopted. Do you share the view of the Democratic attacks that originalism is somehow a quaint and outdated notion of reading the Constitution for what it says?
Senator, I want to say a few things about that, and I appreciate the opportunity. The first is that sometimes we in our discourse today, our civil discourse, use labels as a way to not engage with other people, to treat and divide us and them. And as a judge, I just don't think that's a very fair or appropriate or useful way to engage in discourse. So I'm worried about using labels in ways that are sometimes an excuse for engagement with the ideas, sometimes pejoratively. The truth is, I don't think there's a judge alive who doesn't want to know about whatever legal text he or she is charged with interpreting, something about its original meaning as enacted. And I don't think this is an ideological thing. I look at decisions like Jones, which we've talked about, or decisions like Kylo, the thermal imaging of a home. Is that a search under the Fourth Amendment? The Supreme Court goes back and looks at the original history and says it's equivalent to peeping toms, which of course would be a search under the Fourth Amendment. The Constitution is no less protective today of the people's liberties than it was 200 years ago. Or when we look at Crawford and the right to confront witnesses and not just have pieces of paper flying in evidence that you can't confront reasonably, to cross-examine your opponent, fundamental right of the Sixth Amendment. Look back to the original understanding. That informs us. Or in the Fifth Amendment, Justice Stevens in Apprendi wrote a very fine examination of the original history of the Constitution and said it's not right that an individual should be sentenced to prison and then a hand sentence on the basis of facts a jury hasn't found. Those are all originalist, if you want to put that label on it, opinions, every one of them. You could look at Powell versus McCormick about the qualifications of members of Congress. That was written by Chief Justice Warren. It's a very careful, we might agree or disagree with it, but it's a very careful examination of the original history and understanding of the relevant provisions of the Constitution. Or Heller, Second Amendment case. Justice Scalia and Justice Stevens both, majority and dissent, wrote opinions that are profoundly thoughtful in examining the original history of the Constitution. I guess I'm with so many other people who've come before me, Justice Story, Justice Black, and yes, Justice Kagan, who, sitting at this table, said we're all originalists in this sense. And I believe we are.
Well, Judge, I thank you for that very scholarly and erudite answer. You are right that Justice Kagan gave an answer that had many similar aspects and said, we apply what they say, what they meant to do. So in that sense, we are all originalists. And, you know, you referenced the Kylo case. I think it serves well to rebut the caricature that some on the left try to paint of originalism. They're dealing with thermal imaging. You know, the notion that, gosh, how could the framers possibly imagine modern contrivances, modern contraptions? Well, thermal imaging did not exist in the 1700s. Right. The framers had no idea what it was. And so under the caricature that some of the Democrats have suggested, you would assume the originalists in the case would all line up on the side of saying, well, gosh, the Fourth Amendment doesn't cover that. And yet the Kylo case, the majority opinion, 5-4, was written by Justice Scalia, perhaps the leading originalist on the court. It was joined by Justice Thomas. And indeed, Justice Stevens dissented in that case. And so I think that case illustrates that any judge doing his or her job, a thorough understanding of the original understanding of the language is essential to effectively doing your job. Would you share your thoughts about how the Constitution intersects with modern technology, how a 200-plus-year-old document can possibly be applied in a world of internet and technology and changing reality?
Well, it's just these discussions we've been having, right? You go back and you look to the evidence of what it was understood at the time to protect. Of course, Madison didn't know about thermal imaging or GPS tracking devices or DNA or email. And no one is looking to take us back to the horse and buggy day, or quill pens, or to turn back the clock on anything. The point is to apply the law in a way that allows us to be able to say as judges, it's not what we wish. It's what the law was understood to mean. It has a fixed meaning, as Madison said, in the fixed meaning canon of construction, that the Constitution should have a fixed meaning, right? And the judges may disagree over what that is. We disagree once in a while, not as often as some would like to portray, once in a while. But our disagreements are not political disagreements. They're disagreements over what the law is. That's very important to me. And the other thing it does is it's a due process value. We're interpreting the law in a way that we can charge people with notice of, because we're judging them for their past conduct. People lose their liberty, their property, on the basis of our interpretations of the law. And it seems to me that it should only be fair that there are interpretations we can charge them with notice of. Right? Similar thing when we come to statutory interpretation. Right? What does that text mean? What could a reasonable reader understand that text to mean? You know, my favorite case in statutory interpretation when I teach this stuff and talk to my law clerks about it is the fish case. You know, that there the statute read something like, and I'm not going to get it exactly right, but if you destroy email, documents, or other tangible objects when you know the cops are after you, you go to jail. Well, what does that mean in the context of a fisherman who knows the Coast Guard's after him and he's got an illegal catch and he throws it overboard? That case went to the United States Supreme Court. It's a great case. And it divided in a way that people don't expect, right? Justice Ginsburg wrote the majority opinion, and along with Justice Alito writing a concurrence, saying, fish, this statute's about email. Nah, no notice. Justice Kagan and Justice Scalia wrote a dissent saying, fish, that's a tangible object, right? He had notice. You shouldn't have done it. And so these things don't divide along any kind of ordinary ideological line. I am confident that there are justices who in that case, or in Heller, or in any of these cases, would, as a matter of policy, have come out differently than they did as a matter of judging. And that, to me, is all the difference in the world. We're not doing what we would like, but what we think the law is.
Let's turn to another topic. Some of my colleagues on the Democratic side have raised some questions about the Federalist Society and have raised it with a tone that suggests it is some nefarious and secret organization. Indeed, I was waiting to see the question, are you now or have you ever been a member of the Federalist Society? And given that context, for the sake of candor, I'll go ahead and self-report now. I am and have been a member of the Federalist Society since I was 21 years old and a first-year law student when I happily joined. And indeed, there are over 60,000 members, law students and lawyers, and indeed those just interested in the Constitution and the rule of law. And one of the things that has struck me about the Federalist Society is the incredible range and diversity of opinions within the Federalist Society. You have conservatives, you have libertarians, you have those who believe in fidelity to law and wouldn't ascribe to either of those labels. And I understand you gave a talk at a Federalist Society event at the problems of overcriminalization. Can you tell us a bit about that talk?
Yeah, I think it's fun to go into audiences and challenge them sometimes a bit. I think it's important. And as to the Federalist Society, I don't have a card either. And I really don't want a back statement for past dues. But I attend maybe one event a year or something like that. It's all on my forums that you all have. And at that speech, I did talk to the society about the problem of overcriminalization, as I saw it. On the federal statutory books today, we have approximately 5,000 criminal laws. That doesn't count, of course, all the criminal laws at the state and local level. And Congress pours out a lot of new criminal laws all the time. Most of those laws are a relatively recent vintage. And I asked my law clerks to go find out, okay, now, how many of those, how many laws do we have that have criminal penalties that are in regulations too, right? Just out of curiosity. And I thought they'd be able to come back with a number. And apparently, they reported back, and I trust them, they're pretty smart. They came back and said that scholars have given up trying to count the number. They gave up at around 300,000. And Madison warned, you know, he lived in a time when there were too few written laws, so that the king could pretty much do as he or she wished. Tyrannical king. That's the experience they had. But he foresaw a world and warned about a world in which we have too many laws, to the point where the people can't know what the law is. And of course, there's the great example of Caligula, right, who posted laws, ancient Roman emperor, deliberately posted laws written in a hand so small and up so high that nobody could tell what the law was. Better to keep the people on their toes. So, sorry. And that's a problem too, right? For due process, fair notice. And the truth is, and like so much else in life, we're aiming for the golden mean. Not too much, not too little. Point where people have enough fair notice, but aren't overwhelmed. That's what I spoke about.
Well, and I agree with you. It is a significant problem, one that this committee has addressed multiple times, and I hope will continue to address. Indeed, I'm reminded of one legal thinker who famously observed, "In heaven there is no law, and the lion lies down with the lamb. In hell, there is nothing but law, and due process is meticulously obeyed." And living in a situation where, by the count you just shared, there are over 300,000 potential crimes in a regulatory sense, at some point makes it exceedingly difficult for an honest citizen to conduct himself or herself in a way that doesn't run afoul of the law. And that is something that should concern all of us. You know, I would note, when you gave this speech, would you say it is fair to say that not everyone at the Federalist Society who heard your speech agreed with everything you said?
Oh, goodness, that was the whole point of the speech, Senator.
Well, and in my experience, a great many Federalist Society events are structured as debates, where you have sometimes sharply contrasting views for the purpose of intellectual discussion and hopefully thinking and addressing hard problems.
And there's a counterpart to the Federalist Society now, the American Constitutional Society.
Right.
One of my friends who's just here is on the board, does similar good work.
Sure.
I think these societies, debating societies, useful to ideas percolating and being shared in a civic way, in a way that we can discuss with one another calmly, coolly, thoughtfully, not yelling at one another, not using labels to dismiss one another. That's what I get out of it. I learn things.
I would note that the Federalist Society describes its purpose as, quote, "It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be." And I can think of very few people qualified to be a judge who would not agree with those basic precepts about the foundation of our country. Let me turn to a different topic, which is several of my colleagues on the Democratic side have focused on corporations and have been critical of decisions such as the Supreme Court decisions in Citizens United or Hobby Lobby, and have put forth the proposition that corporations are not people and hence cannot have First Amendment rights, cannot have free speech rights, cannot have religious liberty rights. And while that may be a perfectly fine debating point in a committee of the United States Senate, in a courtroom, it runs foursquare into decades, if not centuries, of precedents on the other side. The New York Times is a corporation. Judge Gorsuch, is there any credible argument that the New York Times enjoys no First Amendment protections whatsoever?
No, Senator.
The NAACP is a corporation. Is there any credible argument that the NAACP has no First Amendment protections?
I think these are long-settled precedents we're talking about.
And the same, I would note, is true for the NRA, for La Raza, for the ACLU. Every one of those is corporations, the Sierra Club, and every one of those the Supreme Court has for decades held. Simon & Schuster, a major book publisher. There is every one of those the Supreme Court has held are protected by the First Amendment. Is that a fair characterization?
I believe it is.
I think that's important to note in the public debate, that part of the reason we have such a robust arena of free speech, part of the reason I think it is a good thing that on gun issues we have the NRA and the Brady Center debating back and forth, citizens of good intentions and morals believing strongly on an issue, expressing their First Amendment rights, petitioning Congress, speaking out publicly. And the First Amendment exists to protect your right on one side or the other to speak and let the public domain resolve that issue. Let me turn to a different issue and return perhaps to a lighter topic. I understand that you like to take your law clerks, some of them very much not from the West, to the Denver Rodeo every year, and to have them observe and react to cattle roping and bronc riding and mutton busting. Is that true? And can you share a bit of your experiences and even better theirs in that regard?
Well, Senator, I get law clerks from all over the country, many from my region. I maybe favor my region, but I get plenty from out of the area too. And we have a great rodeo in Denver every year, the Grand National. And it begins with a parade down 17th Street, which would be like a parade down Pennsylvania Avenue in D.C., where you have cattle. It's a cattle drive down the main road in Denver. They shut it down. That's how you mark the opening of the Grand National. And the closing of the Grand National is celebrated by the prize steer getting to spend a little time in the Brown Palace Hotel. Now, the Brown Palace Hotel is like the Willard, or pick your favorite fancy at the Plaza in New York. Yes, they bring the prize steer into the lobby of the Brown Palace. And in between, there's the rodeo and the stock show. And the kids show their animals. My kids never made it to the Grand National. They're more county fair types with their chickens and their rabbits and dogs and whatever. But the kids compete to the Grand National. This Grand National is big time. And then there's mutton busting. And I think my children still have PTSD from mutton busting. Mutton busting, as you know, comes sort of like bronco busting for adults. You take a poor little kid, you find a sheep, and you attach the one to the other and see how long they can hold on. And, it usually works fine when the sheep has got a lot of wool, and you tell them to hold on. I tell my kids, hold on monkey style, really get in there, right? Get around it. Because if you sit upright, you go flying right off, right? So you want to get in. But the problem when you get in is that you're so locked in that you don't want to let go, right? And so then the poor clown has to come and knock you off the sheet. And my daughters, they got knocked around pretty good over the years.
Well, as a Texan, I think everyone's life could be rendered richer by going to the rodeo, and I thank you for sharing that experience with your clerks.
Well, I'm sorry, all right. We could talk mutton busting all day.
Senator Franken.
Good to see you, Judge. Evidently, there's no animal abuse laws.
You sound like my daughters on that score, Senator.